is the Legislative Committee on Judicial Rules. We unfortunately had to evacuate the State House, and so we have relocated to Aiken Drive, the Ledge Council conference room, and we'll resume our meeting. We had Terry Corsone just starting to give us the background when we needed to evacuate.
Thank you, Madam Chair. I promise it was not me who pulled the alarm to get out and testify. I was starting to say this has to do with Vermont Rule of Electronic Filing 5D.
Right, 5, that's what you're looking at.
And this is the electronic filing rule. It has to do with court staff processing. And the reason why there was an amendment to it in 2021, Courthouse News Service filed a lawsuit in 2021 following the pandemic coinciding with the rollout of electronic filing and electronic case management. And all of the kind of chaos, if you will, that ensued with courts being closed down, court staff leaving, a variety of factors that led to processing times for civil cases in particular. Oh, you're so kind.
Arlene, that is so kind.
One little one, and if I find the second one.
We have one going here and one going over there would be fabulous. By Marty.
Again, apologies.
Right next to Marty.
Okay, this room is not heated, and so we have just gotten the second space heater, and people were very excited.
To save heat, we're gonna close the door, actually.
All right, so back to you again. Sorry, I don't know where you.
That's fine.
There's the wandering house.
Okay.
Thank you so
Call
much.
to order here.
Very cheery.
So when a new filing is made at a court, and this was in the paper world or the e-filing world, there's clerk review, primarily to ensure that confidential information is not in a case filing inadvertently that would then be made publicly accessible once the court case is accepted, because most court cases, as you know, are public. But for the juvenile docket, adoption, and some aspects of criminal, it's all open to the public. So clerk review would ensure that there wasn't confidential information in a case that was going to be publicly accessible. And that was built into our original e-filing rules, and that was similar to the rules for paper filing. However, because of a variety of circumstances that led to a delay in that processing and cases being made publicly accessible, there was a lawsuit brought, and the U.S. District Court issued an injunction that prevented the court from doing any review before new civil complaints became publicly accessible. And that's what prompted the amendment in 2021 to basically acknowledge that this injunction precluded us from doing any pre-access review. And we actually implemented something called the press review tool that had kind of an expedited review built in, because we wanted to minimize the potential exposure for confidential information if it was inadvertently included in the filing. So the 2021 amendment was to indicate that for new civil complaints, there would be no pre-access review in light of the injunction. The judiciary appealed that decision, again, feeling it very critical that we did have the ability to prevent confidential information from being released to the public. And it was with the Second Circuit Court of Appeals. It was appealed. Oral argument was held in 2023, and the decision came down in 2025, earlier this year. And in its decision, the Second Circuit ruled that the injunction was overbroad. It struck down the injunction and specifically made reference to confidential information and the legitimacy of a review to prevent confidential information from being inadvertently released. So as a result, we sought to amend this rule in light of the Second Circuit guidance. We wanted to be able to do the pre-access review, and it's limited to confidential information only. And that's what the rule accomplishes. It states that to ensure the absence of confidential information prior to entry into the case management system, then it indicates that this review will take place. There's then subsequent steps, in addition to the checking for confidential information. You would check for a signature, check to make sure it was the right case type, And then there's kind of case management steps as well. Does this need to be scheduled for a hearing? It gets it routed where it needs to get. All of that review takes place after it's made publicly accessible. But this rule was amended to reflect the new guidance that we do have the ability or we can check for confidential information. So that's the purpose behind the amendment. And it was done on an emergency basis, again, to minimize the risk of confidential information being inadvertently released. Otherwise, if we waited the normal however many months to have it go into effect.
Great, that was very helpful and thorough. So, Justice Philly, did you want to say anything else about the rule before we ask the committee if they have any objections?
He's not really frozen.
I think he's frozen.
No.
Oh,
No.
okay.
Well, that was a good impression.
So,
Justice Dooley, did you want to add anything?
No, I think you've covered the situation. Maybe I should add what happened this morning. It happened that this meeting was scheduled for a date in which the Electronic Filing Rules Committee was meeting. And so we had a shortened meeting this morning. And one of the things we did, because the time for comments had closed without any comments, is that we voted to send it to the Supreme Court. It is, of course, identical to the emergency version, but this would be the permanent version. So it's no longer an emergency, so that it goes through a process of comment before it's finalized. So it's now back again at the, or will be by the end of today, I think, at the Vermont Supreme Court. I just wanted to be sure you understood that procedure.
thank you, which means that we will see it on our next agenda, right, as a permanent change, because it will come back to us.
If the court comments.
If the court comments, yeah. So we do still need the committee to vote on if there are any objections to this emergency rule.
Do you want questions first, or?
I do want questions first. I'm sorry, yes.
Martin's making me go first. So my question is, it's going to require me to sort of understand the process a little bit better. What I'm thinking about is, before we went to e-file, there was definitely one time when Tom Costello made me drive all the way up to Burlington to file a complaint on the last day before the statute of limitations expired. Ran in, got to the court clerk, and had her stamp it to make sure that it was in, right? We had told the statute of limitation we were not gonna lose the case based solely on that. I'm curious here, if I filed something on the last day of before the statute of limitations expires, and it's like 500 pages long, some like crazy complaint, and in what's proposed here, they have to go through a full looking through the whole thing for confidential information before it's even into the electronic file system, where they then get to look to see if it's got the signature and all the things necessary to determine whether it's accepted or not. When is it determined that I've satisfied the filing requirement so that I don't, I'm not over the statute of limitations issue?
When you e-file.
Yeah, okay, that's.
Yeah, the e-filing rules say that as the filer, you get the benefit of the date that you submitted it into the e-filing system.
Yeah.
So regardless of when it's actually accepted, the date that you filed it is the date that you submitted it into the e-filing system.
And
Okay.
the date and time stamp that documents that. Similar to when you went to the court
Yeah.
and the clerk took it and stamped it.
Yeah,
That's the same action result when you enter into the e-filing system.
and that's all before any of the, okay, I could have asked that question faster then.
No,
But that makes sense.
It was exciting.
That's a little
It
story,
was,
yeah.
it was very exciting.
And you don't get that anymore. You don't get to drive all over the state.
You
driving
could
a car.
probably, but.
But okay, so in that case, no, that was my only question.
We do have that process that if, for example, in the course of review, there's an error or something that needs to be corrected, we have the process where you have the 7 days to correct the error, and if you do, you get the original.
The original
Oh, wow.
thing.
Yeah.
Yeah,
That's nice.
yeah.
Can,
And that- would
can
that
I add a comment here that's part of the answer, I think, is you have to look at what the paper world was like and what the electronic world is like that causes problems like this. So in the paper world, somebody filed a case, it went to the clerk stamped it, it was put in the file. But if somebody else came along and said, I want to read that file, the clerk then looked at what was in it to ensure there was no violation of restrictions on public access before giving that file to a person. In the electronic world, you can't do that. You have to, when it's filed, it has to be either publicly accessible or not publicly accessible. And if publicly accessible, it is immediately can be looked at by a third person. That clerk review that occurred in the paper world before they gave out the file can't occur. So this is why you get into these situations in which the press says, but we got it right away before. Yeah, but you got it right away because before handing it to you, somebody could look at it. Now you can't. And so there will be some delay if we're going to have some kind of review before you get access to it.
That makes sense.
Thank you. Other questions?
Yeah, my question's kind of a bit of a tangent, but I'm gonna ask it anyway. So for criminal filings, is the obligation on the state's attorney and the defense counsel to make sure there's not confidential information? Because this just applies to civil filings, right?
That the duty for the filer to ensure compliance with confidentiality rules is across all dockets.
Okay, so is there a review process for criminal filings?
Yes.
The same thing, or and is that?
No, the process here is unique because of the courthouse news service case that is only new civil complaints. The process otherwise for all the other dockets is similar kind of review, although docket to docket you could be checking for different things as part of the review, but it's the same. I mean, they go through, there's a central review team for criminal filings to ensure, again, so that confidential information isn't inadvertently included.
And that never stopped because the lawsuit never happened and the injunction.
That's always been the case.
Right. Okay.
We carved out new civil complaints because of the lawsuit, because there was an injunction that said for new civil complaints, this process needed to be followed.
Okay. Yeah, and the reason I raised that, and just it's kind of a heads up for folks, is that I am looking into, and I've already talked to Terry about this, there's a restriction on access to criminal records or all records electronically by the press, at least being able to access filings online. And that's in 12 VSA section 5. And I'm looking to eliminate that prohibition. And I'm raising it now because presumably, however that is going to be worked out, we'll need rules changes, I'm assuming, for electronic access if we're allowing press, for instance, to access records electronically. So
we have to look to see if there would be any rule changes required or not. I know just in discussing it with the person who plans to propose it, they acknowledge the need to check for confidential information before there would be public access.
okay.
So it'd be a similar process, but that's a good point to look through the rules to see if any rule changes would be needed if that proposal is made and if the legislature chooses to amend the statute.
Okay. All right, thank you. I just wanted to flag that since the people working on the rules are in the room, so
Great.
Otherwise no other questions.
Right.
Any other questions? So are we ready to take a vote on if there are any objections? Anyone in favor of objecting?
Do you just want to ask if you have any objections?
Sure, let's do that.
I'm not in favor of objection.
Okay, thank you.
So, yes?
Okay, all right, so are there any objections?
No.
Okay, great, thank you. Now we are ready for the next one.
Yes.
Okay, I think it's back to me.
And apologies, Snotter is luckily able to do this a little more gracefully, but the Senate bill deadline is today. And so I'm having to be my mind in two places because I have got 3 things left that are still in the work, so I
When did they
apologize.
get a later deadline?
I know you guys are looking, your deadline is weeks.
Long,
Come and gone.
long past.
No, this is the
No,
final.
all right.
Finalizing. We have to
All right, let's go
finalize.
back to the agenda because we have a long agenda still.
And so maybe we want to do 3 or 4
Right.
When is our day?
So
All right,
do I understand it's back to me on the 2 other items that are on the
Yeah.
agenda with respect to electronic filing?
yes,
Yes, okay. One of them I can do really quickly. Can I start?
yes, please.
Yeah, so this is Rule 11 on service. This is another one of those housekeeping amendments. The original version of the rule didn't reflect the fact that we have pro se litigants who are electronically filing. They can do it, they're not required to. And how we give notice to them. And this just says, because we're giving notice to pro se litigants by mail generally, that whatever means are necessary can be used. Again, it reflects what the actually was happening. Something had to happen in that circumstance. So it's nothing new, and there were no comments on it. It is not yet it has been sent to the Supreme Court by the committee because the comment period ended, but it is not yet been adopted by the Supreme Court.
Any comments that anyone has or questions or a questionable comment? No, okay, great. We are ready for the next one.
Okay, and this is the last one. And this actually accompanies another rule change, which is not, as I understand it, before the committee, at least not before the committee at this time. So when electronic filing was introduced, as Terry said back in 2020, it started with the trial courts, and actually it wasn't all the trial courts. It moved geographically around the state. Because that, of course, was where the greatest need was, where most of the cases are filed. And then after a couple of years, it was introduced for the Supreme Court, and went through the process again with the committee and rules of having it there. And we looked around at the various places. Was there other activity that wasn't covered by the electronic filing rules that should be? And one of them was lawyer discipline. That's cases that are in the professional responsibility board, actually in hearing panels, in which there's allegations of ethical violations against a lawyer. The courts haven't been using electronic filing in them, so it's the old paper world in that process, and the efficiency that electronic filing gains you wasn't applicable there. So a process started, just the same kind of process that was used in the trial courts and in the Supreme Court, to introduce electronic filing into the lawyer discipline process. Of course, the number of cases here is much, much smaller than either of the other categories for it. And that process went on actually because there were rules issues in the substance of how the process worked that need to be clarified before you can say, all right, here's how you do electronic filing in that. Well, that working those out finally occurred recently, and 2 sets of amendments of rules resulted. One is the one that is on your list here, which are the procedural rules on electronic filing. First, to add lawyer discipline, Second, the only substantive issue really is whether lawyers who are normally required to file electronically are required when they're the defendant, a lawyer disciplinary process. The rule says no. And then otherwise, just adding them in the procedures and stating how the court administrator can set this process forward to do this. So they are, in a sense, pretty housekeeping because you've gone through all of this before in the trial courts and in the Supreme Court, and this is just doing the same thing in the same way for it. But there were substantive rules needed on the other side, that is on the side of the professional responsibility board, that aren't covered by this. So you understand that. These actually were sent by the committee this morning in its earlier meeting to the Supreme Court this morning.
Thank you. Right.
So that was, I was trying to follow you, John. That's 11F, is that right?
No, I had 11F was the first one I did this morning. It wasn't.
Filing 1, 2, 8,
Or
3,
11F
5.
was the one we just did.
These
are amendments
Oh,
to.
5D, 5D and 6C. Okay, got it.
Yeah.
I'm on the wrong one. I was
Right, no,
wondering if
yeah.
that was not making any sense.
Okay.
Yes. So do we have any comments?
Question,
Question.
or maybe, I think it's.
That's a
Could you
comment.
ask
Question
it
can't
before
be.
I
Question,
comment?
comment. So the exceptions, why the exception for the licensed attorney when they're self-represented in the proceedings before a professional responsibility board? I mean, presumably they're able to file electronically.
Yeah, sure. No.
Yeah, let me give you the process for, I think this is the best answer I can give, which is that when we originally did the trial court, when we did the Supreme Court, we created a special committee of the people who were involved in the kind of litigation that we were talking about, and the Bar Association, and anybody who has a particular role in it. And lawyer discipline, there is a prosecutor for lawyer discipline, and there are various attorneys who do that kind of work naturally. And we say then to them, from the standpoint of the electronic filing committee, is we've thought about it, and here are the questions we have that this committee should answer, that we can take back to the Electronic Filing Rules Committee to draft the actual process rules, which is what you have in front of you. And that original committee, I think on a divided vote, Emily, who's there, may remember, Emily Weatherall, who I think is with you, but I don't know what happened on the fire alarm on that.
Emily, right here.
She didn't make it out of the building.
She may remember the meeting in which the group decided, I think on a divided vote, that the lawyer who is a self-represented litigant now, the self-represented litigant side is more important than the lawyer side, and so we won't require them to electronically file. I'm sure if you're a litigation lawyer, many will electronically file just because they know how to do it. And it's easier to do. And certainly any lawyer for a lawyer, that is a defense lawyer, and defense lawyers are often involved in these cases, has to do it because that's not the self-represented litigant. So I think in fact, it'll mostly still turn out to be that it'll come electronic filing, but they don't have to. That's what was the decision of that group. And so that's what's in the proposed rules.
Do you want more Representative Lalonde, or?
No, that's helpful. Thank you.
All right. So any other questions or comments?
None.
Justice Dooley, thank you so much. And thank you for hanging in there during our evacuation.
Thank you. That's the first time I admit I've been in a time in the legislature at all of evacuation. You've proved that process works.
And it proves the legislature can be very flexible.
Thank you.
Can be. Thank you.
We are on a regular basis.
Yes. All right, so now we are going to move on to agenda item 9, and we have the Honorable Corbett who is with us, and thank you for your patience while we went through our morning so far.
Yes, very good. So, thanks and good morning. My name is Dixon Corbett. I'm serving as chair of the advisory committee on the Vermont Rules of Evidence. Vermont's evidentiary rules are based upon the federal rules of evidence. And one of the roles of the Vermont Advisory Committee is to review the changes and amendments that the federal committees are making to the federal rules and decide whether we should also make those changes or make similar changes to our rules. Each of those decisions is individually made, and we typically do not adopt every single federal rule amendment, but instead we make changes only when we think it's important to do so to maintain consistency between the state and federal rules, and when we think that a change makes sense in the context of Vermont state practice, and when we think that the change is substantively correct and beneficial. The two rule amendments for today are both federal rule amendments that we've decided to adopt for use in Vermont courts. Rule 106 is a procedural rule addressing the question of when during a trial a party may seek to correct a misimpression that's been created. And Rule 615 is also a procedural rule that authorizes judges to exclude witnesses from the courtroom before they've testified so that they don't listen to the testimony and tailor their testimony to conform to the evidence already presented. We discussed Rule 106 in the committee last time. It's since been promulgated by the Vermont Supreme Court. We have not, as a committee, received any comments about the rule. We continue to think that the amendment is appropriate both substantively and to maintain interpretive consistency between the Vermont rule and the federal rule. As for Rule 615, this is our first discussion in the committee. The proposed amendments are meant to clarify that judges have the authority not just to exclude witnesses from the courtroom before they've testified, but also to make orders about whether those sequestered witnesses can be provided with trial testimony of others before they testify. In other words, can the courtroom proceedings be told to the witnesses when they're waiting in the witness room, or can they be provided with transcripts, that sort of thing. As a committee, we felt that the amendment was consistent with existing practice and values in Vermont. The amendment provides needed clarity in the rare circumstance where there has been question about the scope of sequestration orders, and the amendment is helpful to maintain interpretive consistency between the state and federal rule. In other words, we think the amendment ensures that Vermont judges have the authority to preserve the integrity of the trial process when they need it. Due to some different nomenclature and practices between state and federal proceedings, we did spend quite a while discussing how the amendment should be written so that it applies correctly in all different kinds of Vermont proceedings, including not only criminal trials, but also juvenile chins proceedings and termination of parental rights hearings, etc. But we do feel that we address those concerns in this proposal. At this time, we've published the proposed rule for comment, and while comments are not yet closed, we've not received any thus far.
Thank you. So questions or comments, and let's just do them one at a time on 106.
Looks good.
Yeah,
Okay,
Yeah.
how about on
green light.
Eric?
106 requires the vote on what
No.
to object.
Yes, thank you. So I do have that written here in purple and I'm ignoring it. So are there any objections to Rule 106?
None.
No.
None. Great. So moving down to proposed Rule 615, are there any comments or questions?
Also looks good.
I just have a
Yeah.
quick question.
Yes.
So just so I'm fully understanding it when it's in practice, just a simplified version. So at the beginning of a hearing or right before a hearing starts, when a judge is telling witnesses to go wait out in the hallway, this is essentially saying that the judge can also order that that nobody provides them with transcripts and that they can't access any other testimony in any way aside from just being excluded in the hallway. Is that about right?
Exactly, yes.
Okay. Thank you. Nothing further for that.
Thank you. All right. So let's move on. So thank you so much, Judge Corbett. We very much appreciate your being here and your patience this morning.
Yes, very good.
And now we will.
Thank you, Judge.
You're up. So we have the Honorable Timothy Tomasi, and thank you for following us down here. And while I'm talking about following us down here, I just also want to thank Lindsay for getting the logistics of us moved down here and keeping our interruption as minimal a time as possible. We are
Quick thinking, quick creative thinking.
Thank you. So thank you for following us down here. And we understand you have a proposed rule to present.
Yes, thanks. Representative Richardson and Senator Clarkson, members of the committee. I am Tim Tomasi. I'm sitting in Chelsea these days, but I'm here as the chair of the Public Access to Court Records Committee, and we have a couple of rule changes that we've got forward to the committee today. Rule 6. 6B18, I should also mention that our intrepid and excellent reporter, Petra Halsema, is here as well online. And she was able to follow us digitally as well. So excited for that. Essentially, both of these amendments sort of enshrine existing practices that we have been aware of and have been followed for years, but there hadn't been any specific, authorization for them. The first one has to do with making documents that are part of inquest proceedings, which are discovery devices typically used by the state in criminal proceedings or potential criminal proceedings to gather evidence. And those are typically, while Vermont statutes address them in part, they don't have full discussions about them. The last time I think the legislature looked at it was a long time ago. It might be worth looking at again, is to have a holistic view of what might be done. But for now, this document and this proposed amendment essentially follows along with what has been the practice, I believe, in Vermont, and is essentially that those are confidential proceedings and the public doesn't have access to them. Similarly, non-testimonial orders, which are similar to search warrants, which essentially allow the state to make a request of a judge for a warrant to get either some kind of fluid sample, whether it's a swab of your mouth or some blood or other kinds of fluids, for use to test for DNA or other properties in a criminal case, typically. With a search warrant, which is a search warrant to search your house or your car, there's a specific provision in the rule which says that those are not open to public viewing until the officer returns that warrant back. And there's nothing specific about that with regard to non-testimonial orders, but that had been the practice of the courts in the system. In the courts, and my understanding is that we treated them just like search warrants. And so this essentially does the same thing. It mirrors the same approach for the non-testimonial warrant as with a search warrant. And while the interest might not be quite as extreme in the non-testimonial circumstances, there's some concerns about destruction of evidence and things along those lines with a search warrant that might not exist. There still is an incentive to flee, for example, and there also could be a non-testimonial order for a third party who's maybe not a defendant or even a potential defendant, might be someone who's to be excluded from being considered a potential person. So both of these are essentially trying to encapsulate what's the current practice and give some support to it. There was also some confusion, I think, when we passed, there was an amendment a couple of years ago that was passed to Rule 6, which also had a new exception for ex parte submissions by parties, saying that those are not subject to public scrutiny. And so the question was, are these ex parte proceedings? And so instead of leaving that as a question mark, we decided that we would make it clear that if you're doing an inquest, the documents are protected from public access. And if you're doing a non-testimonial order, they're protected until the officer does a return on that warrant. Also, the judge does have the capability, if he wishes or she wishes, under Rule 9 to deviate from this rule. So if there's some reason that it should be open to the public, that can be done. So
Okay,
with that, I'm happy to take questions.
thank you. So, any questions for Judge Monte?
Oh, I should add, the comment period, this did go out for public comment, and that closed last week. And
Yeah, I was gonna say,
we did not get
any comments?
No.
No.
No. Amazed, maybe the entire bar is asleep.
Or, so these are just, this is
Or
just
this-
putting into rule what has been the practice
That's-
anyways.
Yeah,
So it's not.
this is just sort of codifying current practice.
Yeah.
I like those ones.
All right, so any other comments or questions?
Well, I guess the question is whether we have to also codify this in statute. Is that what you're suggesting, or is it sufficient?
I believe that we have the authority to do this as the search warrant, for example, the search warrant provisions are in a rule, and I think that's okay. And I don't think that there's a preclusion for us from dealing with inquests. I think there are a number of issues dealing with the inquest. If you look at it, I know Justice Dooley has been interested in this. It's just that the statutes are kind of old and really talk about stenographers and things. So it's just kind of ripe for maybe looking at to see whether this is an appropriate approach. Similarly, because there's been such a change, I mean, I think if you read the rule reporter's notes, you get a sense that in the old days, an inquest was an in-court proceeding. You'd bring someone in there and you'd have kind of like what we might imagine to be a grand jury proceeding. It's all just kind of quiet, hush hush, nobody has access to it. Nowadays, it's more often the case. While I've been with the court 15 years, I've probably had 4 of those kinds of inquest proceedings, maybe 5. But most of the time, it's a request for documents from someone, and there's a request. You can either come to court to produce these documents, and we do have a hearing set up for it. But 99 times out of 100, they're just going to produce the documents, and we don't have the hearing. So given that the thrust of the inquest is totally different than it was when the statutes were written, it might be worth looking at.
So more than just technical changes, it sounds like, because I'm just wondering if it is technical, changing from stenographers and such, if the court could provide that language to put in our miscellaneous judiciary bill. But if it's more than that, then
I think it's more.
okay, all right, thank you.
All right. So, thank you very much.
Okay.
And we will move on with our lengthy agenda here, so thank you.
Thank you.
Thank you.
So next up is Bridget. And Assay, right? Am I pronouncing that correctly? So
It's
thank
Bridget
you. I
Acey.
know you have a few rules to present.
I do, thank you. I appreciate being able to join the committee this morning. My name is Bridget Acey. I'm here as the chair of the Civil Rules Advisory Committee. And it's nice to see everyone. So we have 3 rules I think that the committee is looking at this morning. The first one is a promulgated change to Rule 65, which the committee did look at before it was promulgated. Is a pretty straightforward change that was just clarifying that when a party wants to ask for a preliminary injunction, they need to file a separate motion. And that isn't largely because the way that the electronic filing system works, there really needs to be a motion filing just to make sure that it comes to the court's attention. There was a much older practice of sometimes just including that request in the complaint that a party filed, but that doesn't work through the docketing system as a motion. So it wouldn't come to the court's attention to address. So I'll stop there if there were any questions on Rule 65.
Are there any objections to Rule 65?
Nope.
No, great. Thank you. We're ready for the next.
Okay, the next one, the committee also looked at previously. These were just some updated cross-references in the appellate rules 10 and 31. So those were not substantive at all, just changing a cross-reference based on the renumbering of a rule.
We love them.
Does anyone have a question? Does anyone have an objection? No, thank you.
The third, the third is a change to Rule 4C, which has to do with service. The committee has seen this rule before as well, but in a different form before it prompted some amendments. So the issue here is that the rule in its previous form had a somewhat narrow provision that allowed a court to appoint someone other than, a law enforcement officer, a sheriff, to serve process. There's been some, there have been, I think, some ongoing discussions around whether there's enough capacity in all counties and municipalities to arrange for timely service, especially when time is an issue. So the committee, I think, have been looking at this rule for a period of time, certainly before I was chair. I think Alan Keyes was here with you talking about it. So ultimately, the rule as proposed by the committee that the court promulgated is expanding the ability of the trial court to appoint an indifferent person to serve process. It can be basically done for good cause. And as the reporter's notes explain, that good cause can include timing issues, not just the saving of costs, which was in the prior rule. The committee also recommended, and the court promulgated the rule to provide for when the service of the order appointing the person to serve process with any other papers served. So, for example, if the appointment has been made for someone to serve a complaint and a summons, when they go to serve the complaint and summons on the defendant, they also have to serve the order from the court that appointed them to do so. And that was to address concerns of, about whether the person being served would understand, kind of the bona fides of the person executing the service if they're not a law enforcement officer. The reporter's notes also indicate, that the court will have discretion to decide whether the person serving the process is suitable to do so, and suggest that a motion filed with the court to ask for this appointment has to justify the person that's being chosen.
Great. So are there any questions before we decide if there are objections? Okay. Are there any objections?
Not for me.
No. Great. Thank you very much.
Thank you.
That was very efficient and very clear. So we very much appreciate it. And thank you for hanging in with us so long this morning.
All right. I hope your morning goes more smoothly from here, and it was nice to see everyone.
Well, it's been exciting thus far.
Yes. And if it weren't for our staff, it would have been even more exciting. We're grateful, totally. All right. So now we have two reporters, I believe. We have Judge Amy Davenport in person, who also followed us down here, and we have the Honorable Carrie Ann McDonald, Katie,
good morning.
On the big screen. So I'll turn it over to you, Tim.
Thank you. For the record, I'm Amy Davenport. I'm a retired judge. I am the reporter for the Family Rules Committee. And Judge McDonald, Katie, as you mentioned, is also here remotely. You have 5 rules. The Family Rules Committee has been very busy. 5 rules, but the good news is that 3 of them you've already gone over, but I will go over them briefly. 5 rules that are about to be promulgated. And then we do have, we want to talk to you a little bit about some of the rules that we're working on right now, 3 rules that we're working on. So let me start with the amendment to Family Rule 1B, which allows for conditions of release to be imposed in a delinquency proceeding prior to the preliminary hearing. This is the statute allows the juvenile court to order a juvenile who's been charged with a delinquency to abide by conditions of release pending a merits hearing, which is the adjudication process for juvenile proceedings. But it doesn't state when. And in the criminal context, in adult court, conditions of release can be imposed prior to arraignment, and which would be the equivalent of a preliminary hearing. And sometimes that can actually keep a defendant out of jail. And so it seemed to us that in the delinquency context, that there could be, probably very few, but there could be cases where it would keep the ability to impose conditions of release, would keep a juvenile from being detained. And so this would, the amendment would allow that. It would require first for the court to find probable cause and to make a finding that conditions of release are necessary to prevent harm. So there would be some thresholds. When you reviewed this the last time, which was back in July, you asked that we try to keep track of the cases, the number of cases that this happens in. Obviously, we haven't started that process yet because it doesn't go into effect until January 1. But I will have some discussions with the court to see if we can keep track of. I don't know whether we can keep track of them, but we can try.
That would be great.
So that is the amendment to Rule 1B. You want to go on? Need to go on to the next one?
We need to, right, yeah. So questions or objections, unobjective.
I have one quick question. Is this, how does this relate to like a flash site?
What's a flash site?
A flash site would be, Judge McDonald, Katie.
So a flash site, when you're talking about if there is there's policies and procedures that each county has, meaning a very serious offense which needs to come before the court. So the idea here is that it gives the ability of the Superior Court judge, meaning the juvenile judge, to issue temporary conditions of release pending that hearing. So a flash site, the prosecutor with the public defender and the judge may have a policy to say the more serious offenses should come in quickly, because not every county has family court every week. Bigger counties may have a juvenile docket that has a couple of hearings every week. In your smaller counties, you might not have juvenile court until 2 weeks or 3 weeks. So that's an independent policy. The idea here is if it's a serious offense, it gives the ability for the judge to issue temporary conditions of release pending the juvenile's appearance at the first hearing. What you may consider an arraignment in the criminal context, we call it a preliminary hearing. And right now, the law does not give the ability for a judge to do that. So it results in these cases potentially waiting for, a couple days to a couple weeks, depending on the size of your county and how often you have juvenile court. So it really provides for a more uniform procedure, the ability to get in more serious offenses, where again, you have to have an affidavit by the law enforcement officer where the judge finds probable cause that the offense has been committed, and to determine whether it's necessary to protect the juvenile or another person or the prevention of harm to property. It actually reflects the language in the Criminal Rule 4, which allows the judge in a criminal case to issue temporary conditions of release pending arraignment. So the idea is to give a little uniformity to the state where there isn't, and a tool for the judge where there isn't right now. So yes, so maybe Chittenden County, where they have court every day, can have a flash site, meaning to have a juvenile come in the very next day. But perhaps in your Grand Isle, where they're not having juvenile court, it may take, a week or so, or maybe even more before juvenile comes in. So,
but our rule requires that a hearing be set within 72 hours if the judge is issuing conditions of release prior to the preliminary hearing. So it would actually force the court to have a hearing even if they didn't have a regular juvenile day scheduled.
And that 72-hour language follows in the statute right now when a judge issues an emergency care order which transfers custody from the custodial parent to DCF or another person. You need to have that preliminary hearing within 72 hours. So that's the law in both delinquency cases, and if you think of CHINS cases, child in need of care supervision, we're removing a child from a parent's care because of either a delinquency or because of neglect or abuse. So it tracks that 72-hour language for this temporary conditions of release.
Did you have a follow-up question?
No,
Okay, all right.
no, that's very helpful.
Any other questions? So are there any objections to well, I'm sorry, this one is, no, we do not. Yeah. No objections? All right, let's move on to the next one.
All right, the next one is a brand new rule, Rule 19, which covers extreme risk protection orders. And that's a statute that you all passed, let's see, and initially in 2018, and then in 2023, you passed additional legislation, you amended that legislation to permit a family or household member to file for an ex parte temporary extreme risk protection order with the provision that if that was issued, if the order was issued, that the state's attorney, the prosecutor would then take the case over. It's a kind of a hybrid procedure. The statute specifically requires a family, the rules for the procedure be family rules as opposed to criminal rules. I think initially the committee, or me, perhaps just me as a reporter, thought, oh, this is going to be similar to some other rules that we have, and then realized that given its hybrid nature, it's really quite a different, it's pretty different. And so it has its own rule. The statute's very specific with respect to procedure, and our proposed rule tracks the statute in terms of what the procedure should be. I'm trying to think if there were any major issues. Perhaps, Judge, can you recall any major issues on this one?
I think when you look at the statute, it says to specifically that the rules of the family rules apply. And when you look in the family rules, there's no ERPO rule. There's no rule related to extreme risk protection orders. So it was really just, we needed a rule because there wasn't one. I think what's makes it really clear in these proceedings here goes through the procedure. But when you look at the statute right now, one question for courts, I think, was not specifically stated, is that if there's service upon the respondent, meaning they have service of either a temporary order for final hearing, or if there was a denial to have a final hearing where the state is seeking to remove either firearms or explosives from the respondent because they're at extreme risk for themselves or others. If that respondent is served and they don't appear, can they be defaulted? There are some collateral consequences as a result of violating extreme risk protection order. It's a misdemeanor. So under the rule, as well as procedure, it makes it clear that you can't be defaulted for failing to appear. The state needs to present clear and convincing evidence with regards to the needs for risk protection order. So that's not, doesn't say that in the statute, but in the rule, it makes it clear you can't be defaulted. And makes sense because there's some collateral consequences. You could be charged with a crime, for violating extreme risk protection order. But it really does track the statute with regards to the procedure, as Judge Davenport said, the difference between a family or household member that first files versus the state, and then the state ultimately becomes the party that needs to proceed in the final hearing if they're seeking a final order.
Could you point specifically to where the defaulted language is? I seem to have overlooked that.
Which language?
Related to that you can't be defaulted
Oh.
if they don't show, is my understanding.
The rule is not applicable. It's subsection A, subsection 2, that the rules that are not applicable would be mediation, alternative dispute resolution, 55 default.
Right.
Oh,
I'm sorry.
So 55 rule, the civil rule 55 it covers default hearings, and it does not apply under A1. I'm sorry, A2. It's one of the rules that does not apply to these proceedings.
I'm sorry.
So it's a little tricky to.
Which doesn't affect the ex parte part of it at all.
No, not at all.
Yeah,
It just
yeah,
means
okay.
that the prosecutor is still going to have to put their case on, even if the defendant doesn't show, or the respondent doesn't show up.
Right, okay, thank you.
Other questions? Does anyone have any objections to this?
Nope.
No,
No.
Great, all right.
Okay, 17F is another rule that you have, that you reviewed back in April. And that's really a simple one. Rule 17 deals with proceedings, rules around what kinds of hearings, what kinds of hearings can be hybrid, what kinds of hearings don't have to be, hybrid, in person versus remote. And Rule 17F says that relief from abuse proceedings are basically hybrid. They could be remote or they could be in person. The amendment in this case is just to add abuse maltreatment prevention for vulnerable adults. That's the statute that for proceedings, for example, where you have an elderly person who has a guardian and there are allegations that the guardian is somehow taking their money or doing something bad, usually financial. And it just adds those proceedings to the existing rule, which covers relief from abuse.
And this is in family court, maybe?
They are both in family court, right?
Oh, interesting.
Yeah.
So
Both of those come to family court, right?
interesting. I appreciated that.
I think this was an exception where RFA hearings, most of the courts have those hybrid where if someone files a petition on behalf of a vulnerable adult seeking a protective order, it didn't say it could be hybrid. Now I think pretty much all judges allow those participants, those litigants, to participate remotely, but this specifically includes it in the rule where I think it was excluded by error, by oversight.
Thank you. Any questions? Does anybody have any objections?
Nope.
No.
Great.
Okay, but now we can move on to the two rules that you have not reviewed yet. One is family rule, an amendment to family rule 4.2E. And that's probably the most complicated of the ones you have in front of you. So 4.2E governs venue for post-judgment motions in domestic cases, divorce, parentage, etc. Under the old rule, current rule, and this rule doesn't change that, venue, that's where the case is going to be heard. So let's say you had kids, it's a case that involves kids, your divorce was finalized in Chittenden County. If there is a motion to amend the order, which a post-judgment motion, which could be, say you're asking for custody, change in custody, or you're asking for change in visitation. Under the current rule, and this doesn't change, if either of the parties or both still live in Chittenden, the case is going to be in Chittenden, is going to stay in Chittenden. But if both parties still live in Vermont, but neither of them live in Chittenden, then the case is going to have to move, right? And so under the current rule, which turned out, the problem with the current rule is that it's really unworkable in the electronic context. Under the current rule, you would have just made the person filing for the modification, for the change, would have filed a motion to change venue to, let's say they now lived in Addison County, to change venue to Addison County, and that paper file would just have been shipped off to Addison. Now that under the new case management system with no paper files to be shipped off, that doesn't work. And what was happening was the plaintiff was, so let's say it's the plaintiff who's asking for the modification. The plaintiff lives in Addison County. The defendant lives now in Windham County. So the plaintiff would file the motion to change venue. Chittenden County would try to serve the motion on the motion to change venue on the defendant in Windham County. That would take some time to get service. Then once they got service, the motion could be granted. The case would then proceed to Addison County. Addison County would say, well, now we have a motion to modify, so now we have to get service again, and so there would be service again. So it was just, yeah, it was taking months. So we originally filed a rule proposal and requested that would make it basically kind of automatic. So if, in the same example, if both parties had moved out of Chittenden County and the plaintiff lived in Addison, and the plaintiff affirmed that they lived in Addison, the defendant lived in Windham, the court on its own motion would change venue without having to require that the plaintiff file a motion to change venue. So that was adopted by, at our request, that was adopted by the Supreme Court as an emergency rule. There were no comments on this emergency rule, but as we discussed it and discussed whether to request that the rule be promulgated, one of the members of our committee said, what happens if you have, for example, the plaintiff, but whoever the moving party is, who wants to keep their address confidential, and they live in a small county where it's going to become very obvious that where they live just by saying what county they live in. Could that party then ask the court to change venue to someplace, for example, to where the other party lives, the defendant lives, to Windham County? And after discussing that, debating it, we decided to propose an amendment to the emergency rule, which simply adds 3 words or 4 words that it's automatic, absent a request otherwise. So so in that particular case, a party could ask that the court change venue to where the other party lives. We think that the number of those cases is very small, but at least it gives doesn't make it always automatic and gives an out there. And so that's the change in the rule. The final rule that we proposed that the emergency rule be amended by adding those 4 words.
And this will make it workable.
It makes it workable, and it also gives an out in the event that they don't want the county to be the county where they live.
Got it. That makes sense.
Questions? Objections?
No.
Yeah, that's hard.
Okay.
And Judge Davenport, if I can talk about the amendment to the Rule 9, because this was interesting of starting as a judge, how this came up for me. The last rule that we have is Rule 9. It's just making a change that would be otherwise promulgated here. So currently under Rule 9, it provides that judges can ask, or I should say parties can ask for an ex parte order for an order of protection of their family or household member, meaning they can file that prior to a hearing. And the court can find that if they find that the plaintiff has been abused by the defendant, abused under the definition in Title 15, meaning cause harm, threaten to cause physical harm. Could also be coercive controlling behavior, could be stalking, could be sexual assault, and that there's immediate danger of further abuse. Under the current rule, there's a provision that says the plaintiff shall be entitled to present evidence to the court before the court decides whether to grant or deny a temporary order, which when you look at it, makes it think that is there some type of proceeding that happens before going into court where the plaintiff is able to speak to the court, to the judge directly, or to have a mini hearing with the judge. It wasn't quite certain, what does that mean? So in asking judges, do you have some type of hearing with the plaintiff that we don't know about before an actual hearing? No, that's not the case. They're reading the documents, the complaint filed by a family or household member that's seeking an ex parte order, meaning an order before the hearing. And the statute allows you to do that. The rule allows you to do that. I think what we became clear is that there's not this proceeding beforehand, but judges can sometimes ask questions or have a question based on the paper that they read, and may have a question that they don't know the answer based on the information provided to the party by the plaintiff. And so it particularly allows the courts, the judges, that before they make a decision, specifically adding the language that they may request the plaintiff provide the court with additional information regarding the facts alleged in the affidavit, and that would be put in an affidavit. So one, it answers any question a judge has in trying to make a decision ex parte. Was there abuse, and is there immediate danger of further abuse? And then it gives it more formality, meaning that it's an affidavit in writing, so that when it's either denied or granted, there's a record of that, so that people would understand why the court either granted the motion for an ex parte order or why they denied it. So I think it clarifies the process, makes it clear, but it doesn't take away the discretion that I think judges are using, but it makes a clear record of that. If there are a question that a judge has, it allows for the plaintiff to provide that additional information to the court, and the court to be able to review that and then make the decision. Is the ex parte order granted or denied? And then if it's denied, the plaintiff can seek an intent to pursue to have a final hearing. If it's granted, a final hearing is set within 14 days. But I know it's a question that I had when I was first a judge, when I read the statute, to say, oh, is there something that I don't know about that's happening? And that started the discussion many years ago. But
that's interesting. It was, well, when you think about it, about probably, I would say roughly 2/3 of these temporary ex parte orders are granted in the middle of the night.
Yeah.
Having a hearing in the middle of the night is really not a possibility, but usually there's a worker with the person who's filing. You can say, well, I have some questions about, can you give me a further affidavit addressing this issue, whatever the issue is. Maybe there's some question about where the abuse took place. Maybe there's some question about what the relationship is between the person involved and this person. I mean, people who are filing for these things aren't always very clear in their affidavits, especially when it's in the middle of the night. So there can easily be something that is just not clear in their affidavit. And this just allows, I think what current practice already is, that you can ask for basically a supplemental affidavit.
So a concern that kind of jumped out at me, but maybe it's decreasing now a little bit, just from hearing from you folks, is that it almost kind of jumped out. It sounded like, you haven't given me sufficient information, try again.
Second chance.
Like a second chance. And I don't know if that's the way it's written, then maybe, if that can be finessed or not. But I mean, from the explanation, you're saying, well, there's specific issues that weren't clearly put forth. I mean, one answer to that is, well, you didn't meet your burden and you're out of luck. And this is kind of, again, saying, well,
but
do you
then they could
understand
just, I understand your concern, but they could just refile, because you do have to explain why you're not granting it, and then they say, oh, okay, the judge didn't understand this, well, you know, I don't want to refile, and you just, but I think it's my own experience and Judge McDonald Katie's experience, maybe, maybe similar. My own experience is that what we're trying to address here are gaps. And the way you would ask for that affidavit is just tell me more about X. But you're not saying yes or no or whatever, you're just saying, I just need more information. If it really doesn't meet the burden of proof, you can just deny.
So can I point out where maybe the problem actually is for me more so is insufficient to support the issuance of a temporary order. Shouldn't it be along the lines of insufficient for the court to rule on the request? Something along those lines, because that almost suggests that, well, you haven't given me enough yet, so go ahead and give me some more, as opposed to you don't have sufficient information to rule one way or the other. And could that be clarified that that's where the information is being sought, just so the court can.
I'm not sure I understand what the difference is between to support the issuance versus to rule on.
It's suggesting that, I mean, that's where it's suggesting I'm giving you more opportunity to give me sufficient information to rule in your favor. I mean, it seems to say, well, you haven't given me enough yet.
Right.
Go ahead and try again. As opposed to, I can't really rule on this yet. There are some things that need to be clarified, and I need you to clarify those issues. It seems to suggest that what the information you're asking for is in fact so that the court can issue the rule or can issue the order.
So
give an example.
Yeah.
Okay. I think.
I could give an example of the information. For example, if someone talks about that I have been physically harmed by my partner, that's not something information where the court's going to be asking for further information. But I'll give you an example of where this has come up, where I have asked the social worker in the evening to ask a clarifying question. When a person is seeking a relief from abuse order on behalf of a child, and it's not clear that they are a parent or a caretaker of that child, because they haven't identified that. That is something where it's jurisdictional, where the court needs to know, are you a parent or are you a legal guardian or are you someone in a parent taking capacity? And when they don't really explain that in the complaint, that is a follow-up of what is the relationship between yourself and the child that you're seeking an order protection on behalf. Those are examples. If someone was filing a petition, a complaint, and they described abuse, I don't think that this is intended to say, well, describe it more in clarity so that the court can grant the temporary relief order.
Even that example, if they answer back as, well, they don't have the right relationship, then presumably you still don't have the sufficient information. Well, I mean, you have the sufficient information now, but the ruling will be, well, I'm not granting it. So it just seems to suggest that the court is asking for information.
Yeah, I hear what you're saying, but I'm wondering whether we could do it this way. Whether this is existing language to support the issuance of the order. It's not, we didn't go back and look at that. And I think the point you make is well taken, that to rule on the request as opposed to support the issuance is more neutral.
Right.
But maybe we could take that back and do a second amendment rather than, this is due to go into effect January 1, right now. And I'm not even sure what the process would be to get the court to.
There would have to be an objection.
To delay.
So we can object.
You
and
could
then
object.
they would have to go back and continue to work on it.
No, I'm fine to not object or having this go into effect if I'm hearing that this will be taken up by the rules committee.
Yeah, I think that could be taken up by the rules committee and we could do a second amendment. We just never even looked at that language.
Yeah, and it didn't bother me as much for some reason with the current language, but with the court requesting specifically, then that ties it together and makes that more problematic for me.
Right.
Because the first thing is that the plaintiff is entitled, and here now the court is asking for the more information, and that's where I think that earlier language becomes a little more problematic.
Well, Judge McDonald, Katie, I think we could bring this to the committee and look for a second amendment. And I think that, I mean, our concern is that the current language isn't being followed. What we've put into place is actually the current practice. And I'm concerned about upending that, but I think that we could go back and look at just changing that phrase to make it more neutral.
Well, those would be an opportunity to object. I haven't objected to a rule, I don't think the 11 years I've been on, but I'm not very objectionable. So I'm happy if the committee is gonna look at that a little further, given my concern.
Well, the judge is the chair, but I would say
part of that is, this is the procedure right now of what the court is able to ask for clarifying information so that they understand. Especially these are affidavits that are written quickly, sometimes overnight, in the middle of the night, to make certain that we understand some of the basic facts that they're providing, not the quality of the facts of understanding relationships or.
And I have no problem with that. It's just that the neutrality of that language, the first part, the first phrase in that sentence changes a little bit with the court saying, that the court's requesting that additional information. That's all. I'm not suggesting the practice is wrong, but the language could be more neutral in that first phrase. So I won't read that anymore.
Other questions?
No, but how do we aren't going to object, but we're going to suggest.
Let's see if we object. So
I'm not.
Are there objections?
No.
Okay.
But we're going to.
There are suggestions.
Yes, there are suggestions.
Yes, and
Which have been noted.
Bring those suggestions
Yes.
back to the committee, and I
Thank
think you'll get another amendment.
Is there a
Shortly
suggested
thereafter.
timetable by which we get something back?
I think you would get something back so that it could get promulgated. It's a fairly simple amendment. I think we could get it done in January, and probably it would become effective July 1.
Okay.
Yeah.
Put it on the agenda for our July meeting.
Yeah.
Is that what we're meeting yet?
Well, we may meet during.
I know we worked on these.
We try to meet during session.
I thought we were going to try to meet in April or something. But we know we need to meet before July.
I'm only saying July 1 because the rules only come into effect. There are 3 amendments and I think we can go over them pretty quickly, but you had asked last time that we talked to you about what we're currently working on. There's an amendment to wage withholding, the rule on wage withholding, which I'll talk briefly about, and then the judge is going to talk about testimony of children in juvenile proceedings and non-testimonial orders in juvenile proceedings.
So, Madam Chair, before we jump into this, we're already past time.
Right.
We have a lot on our agenda still.
So do we want to?
And I'm just curious because we have a fairly robust conversation about Rule 3. And we have a joint legislative management committee that started at 11:30.
Got it.
So I'm just curious.
If we could get
what we wanted
writing instead,
and if everyone's able to stay because we're now past time. And
I am not able to stay. I have another commitment this afternoon.
I can put this in an email.
Okay, that would be great.
On the wage withholding one, part of the email will be to request that the judiciary committees look at the current statutes because they're really out of date.
You might even put in a drafting request to the one who can still draft bills.
And again, we appreciate you doing what we asked of telling us what you're working on, and apologies
No
for
problem.
not dealing with that.
We have to.
Yeah.
No problem.
Thank you. Thank you very much.
Thank you, Judge.
Amy, thank you. That I apologize, but it just our
Good,
time
thank
is-
you. So we do have Judge Treadwell, and we have several witnesses.
And so I'm just going to text over to the other building and say I'm going to be a little.
Can I ask a question about that first as well? Are we going to address the issue of whether this is an appropriate rule, given the statute, that this seems to change that? I mean, is that like a
Maybe talk about Rule 3.
preliminary? Yeah, Rule 3.
And Eric, do you want to Do
specifically,
you feel like you want to speak to that, or should Judge Treadwell speak to that?
I mean,
I think Eric,
I would, yeah, be hoping
We need
for
to-
legislative counsel
Yeah,
that
yeah.
specifically looking at 12 VSA Section 1 and whether a rule can be changed after it's been changed legislatively. I didn't describe that very well, but I'm
No,
sure.
but
it will.
I think
Because I think that's a preliminary, if we
Sure.
decide that this is a rule that
can't be
can't be
changed,
by
then
rule,
we, yeah.
then, and it only can be changed by statute, then we don't need to have the rest of the testimony now, because it would be,
right,
in up the hill.
yeah, and maybe if we didn't change it by rule, we could have the crowd that hasn't weighed in as much on this and have them review it and propose a best practice. I'm gonna take it and have a discussion legislatively.
Right, so that, I mean, just, I'm saying that.
Yeah, so that makes sense. So,
I give you a quick 2 minutes on
yes,
that.
thank you.
So we're in 12 VSA 1?
Yes.
Yes, we are on our,
No, I just, what you're talking about with this.
I can give you a quick background, but I'm gonna be very quick. So, obviously, this is a committee, or a decision for the committee, but what Representative Lalonde was referring to is that there is language in 12 ESA Section 1 that provides that, after a rule, has been changed or amended by the Legislative Committee on Judicial Rules, it can generally then be amended again by the court. Generally true. However, in this particular case, because it involves Rule 3, which has a very unique history of both the court and the legislature going back and forth time and time again. Some years the courts will make amendments, some years the legislature will make amendments. I remember the very first year I started here, I'm sure senators who were here who were at that time will remember this well. Lengthy bills amending Rule 3. A few years later, the court issues rules amending it also. So in this particular case, although that language in 12 VSA Section 1 generally provides that the court isn't able to revise, or I don't have the rule right in front of me, I think it's revise or amend rules after the legislature is acted. I'm not sure that this would be a case where that would control, because of this long-standing back and forth between. Now, I don't know for sure. I'm not the judge who would be sitting in the chair ruling on that question of statutory interpretation, but that's my take on it now. Does that make, first of all, does everybody understand?
So your take on it is we should proceed?
Not should, can.
But,
You can.
or we could proceed legislatively.
Yeah, you could do either. Yeah, you could listen to what the court has to say. You also are free to, if you decide that you don't like what the rule, and first of all, let me back up even more. The rule is only proposed. So right now, there's no promulgated rule. There's no formal objection. There's only a comment that this committee would make. So, but you could, at any time, in the miscellaneous bill or anywhere else, you could amend it yourself in the future if you don't like where the court's promulgated rule ends up coming down. Absolutely good.
So does it, so the situation where the legislature might amend the rule and then the Rules Committee amends it as well, but it could be different parts of the rule. And in this particular instance, it seems to be reversing or actually directly addressing what the legislature did. I mean, it's eliminating language. It's undoing.
It's undoing.
That's correct.
And that seems to be, that raises a bigger question for me. And I guess maybe we need to hear why that makes sense from the witness, but it's not as clear
as just going back and the
Yeah, that's a fair point.
So,
So given the.
Wait, you're on this committee? That's right.
Yeah. Given the history of this, right, it's got a long storied history, obviously, and our timeline today, all the witnesses, could we do something as simply a motion to delay?
Delay.
Like
taking this up today.
For yourself, you mean, to decide when to hear it as a committee?
No,
That's
no.
15 minutes,
Oh,
but
15,
I'm
right,
45
okay.
minutes late.
I'm sorry, I knew.
Because Randy is.
Right, so we're gonna lose our
With
quorum.
people that have other meetings,
So-
Randy can't stay, I have an obligation. later this afternoon in Rutland and.
Well,
So-
quick, you can count and see how many people have to go and whether you might still have a quorum. Another point is that because there is no formal action that you can take today yet, because it's only in the comment stage, sometimes the committee will proceed in those situations without a quorum, because there's no votes that can be taken, no formal votes that will be taken at
And
this.
share that information.
But
That's up to you.
But I would argue that it's the most substantive discussion we're gonna have today. And I think it's the one that more of us have been thinking about and certainly been talking about the advocates with. And I actually selfishly would like to be part of that conversation. I know that's a totally selfish request, but
Are we able to
What's-
reschedule?
It's not just a simple
Right,
little rule change.
if
No,
we
it's not.
rescheduled another meeting,
could we do it all by Zoom so that we could do it next week?
You can certainly do it, yeah.
And just this rule.
And justice, which would take, hopefully, if we could do that in an hour, my guess is we could do it in an hour or an hour and a half.
are people in favor? And I realize we've brought a lot of people here.
Well, we have a lot of people here
Yes.
and we have people online.
I know,
Including judges.
and I don't know if we can,
Let me just see what's happening over at jail. See, they said they'd shout if they needed me to vote on it.
should we also hear from Judge Treadwell, like why?
Can we hear on the first issue as far as the argument of why
Right.
we should even be taking this up?
Right,
Yes, that's a that would be great.
Because could we make that decision now, potentially? To just like, if we're gonna take it up in committee, to just not,
Right.
yeah.
So if we're gonna hear why we're gonna take it up, or are we gonna hear why we shouldn't?
Well, I'd love to hear from you. What do you think, Martin?
That's a good point. If anybody, any of the witnesses
So-
want to weigh in just on that, right?
so maybe we can agree what time we're gonna adjourn and ask everyone to be as succinct as possible. So what time do people need to absolutely leave there by?
Oh, 45 minutes ago.
Yeah, okay, but I can stay till 1, but that's it.
Okay,
Yeah. 1.
so
I know.
let's ask everyone to be, and I know we have several witnesses, and I don't know if rather than have people repeat arguments, if they're, be coordinated.
So just to clarify, Barbara, just so I understand, what we're asking Judge Treadwell right now is to discuss solely why this is not
Exactly.
violating
Yeah.
12 VSA 1, and we
Right.
should just take this up in committee.
Okay, okay, perfect, yes. Thank you. Hello.
Good afternoon, everyone. My apologies for not being able to be there in person. And it's good to see many familiar faces. And I think I understand my marching orders at this point, which is solely to address the issue of whether this change should be taken up as a rule. And I don't know that I have significant amount to add to what Eric said. I am familiar with the long history with Rule 3 in both the legislature and the Criminal Rules Committee. I was at the AG's office when we did the 2001 legislative amendment to Rule 3, and I think I'm fairly sure Eric was the legislative council person who worked on that proposal at the time. Subsequently, both the legislature and the court have amended the rule. The rule stands in a sort of unusual position, addressing both substantive rights of individuals with respect to arrest powers, and also court procedures, the processes for getting people arrested without warrant into courts. And there is an interesting discussion in the reporter's notes from an amendment in 1988 about the dual, let's say, dual jurisdiction piece with respect to this rule, that both the legislature and the judiciary have acted regularly to amend the rule in question. With respect to the specific amendment here, it has also already, this section 3K, been subject to multiple amendments. It was part of the 2001 enactment, then it was amended in 2018 in Act 164 as part of the significant bail amendments that were enacted that year. Then it was amended by the Judiciary, an emergency amendment in 2018 to clarify basically how the language would work. Then it was amended again the following year by the legislature. And then, the Criminal Rules Committee has gone back to it to address what we perceive as significant issues with the language in the existing rule, particularly the fact that it misstates law and procedure in suggesting that law enforcement actually charges people. That is an obligation and a right that belongs solely to the prosecutors. So there is an article retired Justice Dooley wrote many years ago about Vermont's constitutional provisions and the statutes relating to rule amendments and the authority of both the judiciary and the legislature in that area. I'm sure Eric is familiar with it, but it does reference the idea of ping pong, basically, that there are certain rules and certain issues which are amenable to both action by the legislature and judiciary. And given the rights and issues at play in Rule 3, this seems to be one of those areas. That's why criminal rules went forward. I don't know if there are any questions from the committee on that particular point at this time.
Yes.
So, I mean, are there examples in the back and forth where the criminal rules committee reverses or directly some language that the legislature has put into the rule?
I am not familiar with any that seem that involve that exact change, but there have been a significant number of amendments over the years.
I guess I'm also wondering if I understand it would be easier if the legislature hadn't gotten it wrong.
I have no comment.
Officer, but I'm wondering, should the legislature be the one that's fixing what it got wrong rather than the rules committee?
Maybe we should fix our own problem.
Well, the legislature can certainly do that. And given the rules promulgation process, it may well be that a legislative enactment might be effective before any rule could be promulgated.
So my proposal is that we do take that up, because I think there's a lot of testimony that we have to hear, and we need to dig into this quite a bit, given how many objections there are to this rule already, in trying to figure that out right here rather than in the process
that we went through originally.
Can I just make one brief point, just to make sure the record is clear on this? This rule was sent out for comment in October, and I know your agenda says the deadline was December 6th for submitting comments. It was actually November 5th. No comments were received by November 5th, and no comments have been received to date regarding this proposed rule from any members of the bar.
You are kidding. Well, I mean, I know you're not kidding, John. I mean, given the number of comments we've gotten, I am a little surprised.
Yes.
Okay, so
I think just given also what I've heard about this rule, I would say that point more speaks to the we need to do a better job of pushing out these rules for comments, because clearly they're not getting to people in a way that they're actually able to address them, because this clearly has we have a bunch of people who want to talk about it. So
okay, so I guess we need to decide at this point what we're going to do. It sounds like trying to deal with it legislatively makes sense. I don't know if we still feel like we should be meeting next week to talk about that further, or if we are comfortable, like I do want to hear from all of you, I guess.
I mean, I think we could have a committee bill if we need it, or a short form to get into it, right, Eric? I mean, I know that we're past the drafting.
Their committee bill deadline's later than ours, right?
Yeah, absolutely. There's time for either one of those.
The short form would be great. Well, it seems like we're gonna have to get digging into this pretty deeply, and it makes sense.
Or at least more deeply than we have time for now.
Right.
Yeah, or for this particular committee, the Judicial Rules Committee, I mean, this is pretty unique, and at least.
I have never
I
gotten
know, oh,
to
good,
that
I'm
point.
so glad.
To that point, I have never gotten as many comments on a judicial rules issue ever than this. Other than electronic filing, I will say electronic filing, I got masses of feedback on that.
I'll go one further. I've never gotten a comment from anybody as long as I've been on this committee.
Notter, I know you, I just want to make sure we're not forgetting about you on.
Yeah, thanks. No, I think that discussing this in committee makes sense. I was curious about the timelines based on the fact that, on the Senate side, the deadline is, well, today to make any changes to bills that we've requested. So I can't recall what it is for the House though.
They have more time, but you and I, we have until January 30th for committee bills.
For committee bills, yeah.
But
So, I mean,
again,
yeah, I'm not opposed to discussing it in our committee either. Yeah.
Okay. So we can, Nader and I can coordinate and determine who will take it up first, but we plan on doing that.
And is there anyone, Judge Treadwell or any of the witnesses that feel the need to say anything before we adjourn, given, I guess we should take a vote too, right, about that.
Eric has a question.
Well, I was just going to say, as far as as you think about whether a short form committee bill, if you think about that going forward, I might suggest a committee bill only because if it were a short form, you would have to put at least something in there that had sort of pre-decided what way you wanted it. But if you just want it to be open, like, hey, we want to listen to witnesses and then make the decision yourself, committee bill might be the right
I'm suggesting
to choose.
Okay, yeah, thank you.
Yeah. But as far as whether you need to take any formal action, since it's in the comment stage, you don't need to, but on the other hand, you're not prohibited from it either. So if you wanted to have an informal vote on the record that said, the committee has after consideration has decided that it feels that this issue is one that is appropriate for legislative consideration, and rather than comment on the merits of the proposal today, you're going to wait and try and discuss and listen to that issue during the legislative committee process in one body or the other, once the legislature comes back into session, something of that nature.
So moved. What that is, do we need to repeat the?
I can, actually, that's a great thing about YouTube. I can actually go back and see what I said.
Yeah.
Because right now I can't remember.
I'll make the motion that Eric just laid out for us.
Do we have a second? Okay, all in favor?
Just do a committee.
Yeah, to send it back.
Yeah, exactly.
Send it back.
Take it up in the committee process and decide to do a bill or not, depending on what you want to do.
Assuming that we can rely on YouTube for
That's
accuracy.
true. That is sketchy.
Actually, this is actually one of the great uses of this process that most of us can't bear. Is this will be so public. It is then able to be reviewed.
Can I ask a clarifying question? Is that a request to the court not to act on this rule? I
Yeah.
thought the rule is in a proposed stage, so.
I don't think it would make sense to have dual tracks on the same thing.
I agree.
So would an amendment to the.
I mean, I'm not asking for official action, I'm just asking for some clarification from the committee.
Yeah, I mean, I think it's up to the court and what it wants to do. I don't think we can tell our sister branch what they.
Well, we do that with legislation all the time, don't we?
Well,
yeah, but we try not to.
But yeah, I think there's a commitment to take this up in
This
the
session.
legislature.
Right. So maybe then to delay and wait and see what we do.
Ideally,
participate in our process.
I would say, yeah.
Yes, I think that's what
we're.
we're.
All to come in and testify on this.
right.
So.
Is that clear, everyone? Okay, good.
Okay, so we have a motion that sort of just got amended a little. We're not really, because that was just a.
Well, it's a request and a.
Right, yeah.
To delay court action and to proceed legislatively.
Right. So all in favor of that motion that has been seconded?
Aye.
Opposed? Nutter, are you in or out?
Sorry, I was muted. I support it.
Aye, okay.
I heard you, Nutter.
Yeah, so, there, I guess we can take a motion to adjourn.
And I guess I would just ask, before we do that, I would just ask all these witnesses who've come and made time to do this today, if they would get us their written comments, which would be helpful too. I mean, obviously, if we're going through the legislative process, well, I encourage you to get your thoughts together and put them on paper at some point as soon as possible. That'd be great.
Thank you, and I know people waited all morning for the chance not to testify and present your information, and thank you sorry that we got so behind schedule, and
John is now very happy he did not make the drive all.
Yes.
Thank you. Yes.
He's missing the cookies.
Yeah.
That's true.
All right.
Thank you, Judge. Thank you very much,
So
Judge.
I think we can adjourn.
So yeah, I'll try and reflect that motion in the minutes, but everyone, I think, understands and agrees on the substance. And also just, it's very interesting, how often you get comments. I've been in the council committee for a long time, and I think this is the first time I've ever seen this process happen exactly. So we always get something new. That's what's interesting.
We're still live, and so we're going to adjourn. We definitely will need to meet at least once before July 1st. So just know that when you get your doodle poll, please respond.
And I would ask another question, which is of Nodder and Martin, which is, as we take this up, if you'd be kind enough to notify your fellow Judicial Rules Committee members so that we can come and participate and listen to the testimony